With Ola. This is Mujola Olua, and I'm so thrilled to have you here. Today, we want to talk about administration of estates. That's one area of law where I've got the most questions on this channel. There are a few areas of law where the questions keep coming, people keep making inquiries, sending emails, and whatnot. So today, we want to talk about address some of the most important concerns that people have raised over the years. So don't forget that if you need to book a paid consultation where you get to explain in detail your own personal peculiar situation or circumstance to get tailored advice, you can do that by using the link in the description box. Please desist from putting your personal information in the comment section just like that, because we will not be held responsible. Also desist from sending us emails detailing your personal experience as if you're having a consultation, because we don't take free consultations by email. If you're asking a question that will generally benefit everyone, I've told you times on number that we welcome those questions. We are eager to answer them, and we get to them as soon as possible. But if it is something that will only benefit you, which answer will only be tailored to you, you need to book a paid consultation. Very important. Someone even sent me their dad's will and asked a lot of questions. It was a long email and the will attached. Please, we don't do that. In most cases, I don't even read. Once I see that that's what you're about, I don't even get to the end of it, because that's not how we run here. I run a virtual law firm, but it's on all fours with a physical law firm. The only difference is that it is not physical. So whatever you cannot do in a physical law firm, you cannot do at OM Livingstones and Co. And on Bar Talk with Ola, we provide free information and free education, legal education, because one thing I love to do is to talk about law. But if you want to take a step further and retain our services, make us your lawyers. That is, if you want us to be bound by what we tell you, the information we give to you, you want to act on it legally and be able to say that this person told me to do this, that person said this is what we are to do, then you need to create legal relations by furnishing the appropriate consideration. Please watch the video on contracts so that you can understand what I mean by that. Today I want to talk about administration of estates for people who have died without making a will. I've said that times unnumbered on the channel, but I'm going to say it again, that when someone dies without a will, we say that they have died intestate. Intestate. So if someone has died intestate, how will their will be administered? And I'm making this video because I'm holding this session because of so many things, that I've heard over the years, so many things that people have experienced. Usually when someone goes to the bank, maybe they want to withdraw money from the account of their loved one that has died, or they want to claim a certain benefit, maybe from the person's place of work where they worked before they died, maybe pension or something, or maybe they want to get the person's dividends from shareholding. Then they tell them to go and bring a letter of administration. And the funny thing is that those bankers, those people will tell them as if it's something you just go and come back and you get the letter. It doesn't work that way. Times unnumbered, people have had to be told that that is not how it works. Hi Lucas, if you're joining, you can join us in the comment section. Tell us what you'd like to add to the conversation, any question that you have. Thank you very much. So, and share the video, share the link too with your friends. Thank you so much. Join the channel. Don't forget, subscribe to the channel. Keep liking the videos. Thank you, thank you, thank you. So, it's not a day's job or a day's journey. That's the first thing I want to clarify. So when you go to the bank, you want to withdraw money from your late loved one's account, and tell you, oh, you can't do that anymore because the person is not alive. Go and bring a letter of administration. It is not something you just walk into a lawyer's office and they'll issue to you. Sometimes they probably even tell you to go to court. I was at the probate registry once when a man came to the probate registry and he was telling the registrar that he went to the bank, he wanted to withdraw money from, I think, his brother's account, and they told him to go and bring a letter of administration. So he came to the registrar. The registrar now had to explain to him that you have to take a form, you have to write an application, start this process, And he was surprised because the way they had told him, it was as if you just go, you get the letter, you come back, and you get the money. It doesn't work that way. So what is a letter of administration? A letter of administration is the lawful authority granted you by the rightful authority, usually the state, through the courts of law or the probate registry or the probate registrar, giving you, authorizing you to operate and administer the estate of your late loved one or late next of kin. So when someone has died, because they can no longer do the things they would have done regarding what they own, their property, both monies in bank, landed property, movable and immovable property. Someone can operate those things on their behalf who is connected to them by blood, birth, or marriage, and the person must get a lawful authority, a written lawful authorization from the government through the court or the probate registry, and that is what we call, that authorization is what we call letters of administration. Letters of administration. So I've done both types because there are different ways of getting it. In some states you can apply to the court and you will get it. In some other states you need to apply to the probate registry. You will even have to go to court. So when you apply to court, you go by way of motion, which is an application before the court. When you go to the probate registry, you apply by way of a letter of application to the probate registrar, and then that's how you kickstart the process. This also involves paying some monies, because also one other thing that people are shocked that people have expressed over time is they are shocked that they will pay money. Yes, in life you use money to look for money, so you have to pay some amounts as stipulated by the state where you are processing the letters of administration. You have to pay something, and then also you pay a percentage of the property you seek to administer, as may be valued by the state. You pay it back into the coffers of the state before you can take the rest. That's also one thing that people don't know. I remember, or I recall, there was a time when I was processing the letters of administration for a particular estate of a deceased man for his wife and kids. And then when the probate registry had given us, the valuation of the property, the percentage we were to pay to the government, the wife was almost mad, and, shocked and irate that she's going to pay that amount of money. I told her, you're not paying it to me, oh. In fact, you can go and pay it yourself. This is the authorization. Take it to the bank, pay it, and bring me proof of payment. I'm not going to pay it on your behalf. I don't even do that with clients. So you're paying it to the government. It is a legal stipulation. It's not according to the whims and caprices, even of the probate registrar, because there's a statutory percentage that they must gauge the estate by and charge charge you for. So that is one other thing that you need to clear. So what do you do if your loved one has died and they have not made a will stating how they want their estate to be administered? We've told you that estate talks about, or we've mentioned rather, let me not use we've told you, because we're having a conversation. So we've mentioned that estate covers landed property, residential houses, monies in bank, pension, gratuity, what you have from where you have worked that you're supposed to claim, what you have, from the things that you've acquired in your lifetime, shares, the value of your shares, the dividends, everything that you have acquired that you own or that is ownable, those things constitute your estate, which if you have made a will, you would have clearly stated how those things will be managed, how those things will be administered. But because you have now died because the person has gone to the great beyond without making that will, we've talked about wills and codicils on this channel. There are 2 episodes dedicated to wills and codicils. In fact, there's another episode where we drafted a live will. So that was specifically for law school students. But if anyone wants to see it, just go to the playlist on administration of estates. We did that about 4 years ago, administration of estates. So you will see those things. So since you have not made that will saying how you want it to be done, you will now need an authorization from the state, allowing the people you have left behind to do those things on your behalf. Now, there's a line of intestate succession by law. If you check the administration of estates law of your state, which is what you will check, whichever state you check, the state where the person that died was domiciled, or where they own those properties. So you can start the process from that state. So when you check the administration of estate law of that state, it will show you the line of intestate succession. That is, if someone has died without a will, who are people that can apply lawfully for letters of administration? Because it's not just anybody. An uncle will not just come and say, oh, we are fighting the wife and the kids, let us go and get letters of administration while they are still alive, and they will administer the properties without their own knowledge and input. No. By law, the wife takes precedence, the husband takes precedence. So surviving spouse comes first, then the children, then other relatives come, father, mother, grandfather, grandmother, brother, sisters, uncles, aunties. They all come and they take their places in the line, in the tree. We have also done a video on the line of intestate succession. Go and watch that video so that you will know what level or stage each person comes in the administration of an intestate estate. So now, when you have ascertained that you are the rightful administrator, what do you do? Now, by law, there must be at least 2 administrators. They can be more than 2, they can be 3, 4, 5, and so on. But depending on the estate and what is good for the estate, that's most likely what you will need to determine or decide how many administrators you will pick. So, but at the base, there must be 2. So let's say now you're ready. You have picked the administrator, maybe the wife and one kid who is an adult, because it's an adult kid that the law deals with, not a minor. So, or maybe you have picked the wife and the deceased brother as the administrators. What next do? They need to start the process by making an application. So usually it is something that anyone can do on their own, but it's advisable to employ the services of a lawyer. Now, I'll tell you the truth on the channel. You can do it yourself if you're keen enough, and if you put your ducks in a row, you can do it yourself, But if you don't want to go through the stress, what you're paying the lawyer for is so that the lawyer will take that stress off you. And since it is the lawyer's natural turf, what they do every other day and every day, they are able to have a seamless, process for you. But if you want to commit to it and do it, because if you go to the probate registry, you find laymen there, you find people, everyday people there who are not lawyers, who are processing their own letters of the letters of administration for their deceased king's estate. So you can do it yourself. You can employ the services of a lawyer. So let's say that you started the process. You have to pay the lawyer if you employ the service of a lawyer, and there's no fixed charge. A lawyer could charge you a percentage of the value of the estate according to your estimation. A lawyer could also charge you a flat rate. So, but you have to pay the lawyer. So what they will do, or what you will do if you're doing it yourself, is you write an application letter to the probate registrar. If you're in Lagos, for instance, you can do it at the probate registry. There are some states where you apply to court. So you file a motion. That's when you may need a lawyer. You most likely will need a lawyer, because a lawyer can file and affix their seal. You don't have a lawyer's seal for applications before the court, so you would need to employ a lawyer, and the lawyer will do the process. But if it's a place where you go to the probate registry straight away, you can write an application to the probate registrar. You just edit application for letters of administration for the estate of so person, the full name, late so person. So then you explain yourself. Oh, we are the proposed administrators to the estate of so and so person. The person died on the so at so place, and their last known address is so and so, and these are the proposed administrators' name and who they are to the person. We hope that you expedite action, or we anticipate a smooth process, or we await for the further directives or something. Then you address it to the probate registrar of the probate registry where you want to do it. You go to the state high court. If you go to the state high courts have probate registry within their premises. So also, if you're at a loss, that's one other thing that I want to tell you people, and that I always like to tell people. If you're at a loss on any of these procedures, just head to the probate registry and talk to a registrar. They will explain the entire process to you, even if you have employed the service of a lawyer. Because I know some people employ the service of a lawyer and then they are suspicious. They have no trust in the lawyer, so they are second guessing everything the lawyer does. Oh, is this person trying to swindle us? This person, go to the probate registry, and talk to the registrar. They will explain what is going on to you and how things should be. I recall that there was a time when I processed letters of administration for a particular family, and then, after we had done it, while I was doing it, they asked that we should remove immovable property while we were already in the process, and we had reached an advanced stage, so I had to apply to exclude immovable properties from the estates covered by the letter of administration, and then we went on, we proceeded. So after I concluded and got them the letter of administration and delivered it to them, they then decided that there were more parts of the estate that they wanted to administer that were not included. These people, you gave me the information of what you wanted, and that is what we worked on. I'm not a part of your family, and I'm not privy to the content of this person's estate, which is natural for a lawyer. I have done my best for you. And then they now went to the registry and spoke to the registrar and bad-mouthed me to the registrar, made it look as if I excluded that part when they had specifically instructed that I should exclude it. So thank God they spoke to the registrar that had handled the file, because I had actually introduced them to the registrar, because I'm a very straightforward, my practice is very transparent and straightforward. So if you want to talk to the registrar behind my back, this is the person's number, this is the person's name, this is the registrar. So the registrar and I then spoke with me. Something happened, I called the registrar, maybe the registrar called me, and then the registrar was like, this your client came, they said so and so and so. I was so disappointed. So the next time they reached out to me to actually add to the estate, just as they had gone ahead to talk to the registrar before. I don't know what the registrar told them. Maybe the registrar told them that they should go to the lawyer. The lawyer should add those things for them, since the lawyer had processed it. And I told them, did you not go to the registrar to say this and this and this? They wanted to deny at first. Then I quoted what they had said to the registrar, that the registrar told me verbatim, near verbatim. And then they were like, oh, sorry, not really, we weren't trying to badmouth you. Actually, that mama is like this, so she was just saying, it's a misunderstanding, this and that. I say, okay, me, I've done what you briefed me to do. If you need further things, please go ahead and maybe brief another person, or go and do it yourself. This case is done and dusted. Thankfully, there's no bar to who can add or remove. There's no law that says that the lawyer that started it should continue it. But what most people don't understand, that it's best if you stick to a lawyer for processes that are in the same class, because even those you are going to meet in court, they know that if not that a client is troublesome or something is going on, they don't change lawyers like this. Sometimes people speak to me and they say things about their lawyers, and then they want to employ my own services. It is in fact very common, very common. I always look at it like, if you can say this about your current lawyer, what will you say about me? I have so much respect and deference for my colleagues at the bar. So there are some things are true. There are situations where a lawyer might have acted ultra vires or acted in a very indecent or inappropriate manner. But in many instances, clients talk and act as if they want to pit lawyers against one another. It's not a battle, don't do these things. It ain't no battle. So that is it. You can go to the probate registry, make your own findings. These things are free of charge. Make your own findings, so that you will not be accusing your lawyer of doing what the lawyer did not do. So very important. So after you've made your findings, you take a form depending on, so let's just use a sample now. If you're going to Lagos, for instance, there are some places where you can also start it online. They have a probate registry made virtual where you can start the process. But in my experience, I don't think I know of any state where you can start and complete the process online. In most cases, you might have to start online, print out some forms, and then go submit it physically. So you will provide details. This is why not just anybody can do it. So if you're an uncle trying to swindle your younger brother or younger sister, spouse, or kids of the estate of their late father or their late mother, you may not know some things that are important, This is why the proper person should do it. And it's a process that requires unity. Because if someone goes ahead and during publication it is flagged by other members of the family, that procedure may be paused, and an embargo may be placed on it by the government, and so everybody will just lose out if they are unable to resolve. So it's important for unity to be in the family before you go ahead and do what you have to do. So you have to provide information, basically the person's biodata, where they lived, where the last known address, their name, their age, where they died. You also have to provide the certificate of their death issued by the National Population Commission, not the one issued by the doctor that shows time of death, cause of death, or by the hospital, not that one, because some people make that mistake too. I remember when I was processing for the client I talked about, they first brought me that one issued by the doctor. That's not the one we're asking for. We're asking for the one from the National Populations Commission. You will go there, you will pay a certain amount of money to get that certificate of death, and then you will attach it to your application. You would also attach the deceased valid ID card. Then you attach the deceased passport. You attach the deceased passport and other things that may be required. So just go and make your findings. I don't want to say this, that, in case some things have changed or in case it is not applicable in your own situation. You also provide the information of the administrators and their means of identification, their connection to the deceased, and passports. Another issue that usually comes up is the issue of difference in name, because you have to do an affidavit at some point. So sometimes it raises a question, it may be flagged if maybe the deceased is Mr. Ojo, and then the people that want to administer the estate are Aina, Shegun. So they want to know if we're following the line of intestate succession, everyone in a family unit, father, mother, their children, should have the same name. So if the names are different, they might flag it and ask why. It's not that it's not possible for you to process it is, but the property registrar will want to know, why are the names different? Did someone get married? Maybe a child that is married, maybe a female child that has done change of name. What happened? Who are these persons? And what is the actual proof of their connection to the deceased according to the line of intestate succession? So that's one of the things you should be wary of. So if you don't want to go through extra trouble, you may just choose the administrators that bear the same name as the deceased. Note that I did not say that if the names are different, you cannot get letters of administration. I'm just saying that questions may arise, because that is what I have experienced while processing for a client. So questions may arise. They may want to know why the names are different, and it may cause a slight delay, and so just take note of that. So when you have paid, you pay for, you take a form, you pay, then let's talk about the time that it takes. It takes a while. So you can just budget between 6 months and 2 years. It shouldn't take that long actually. But when you get to the probate registry, you know what I'm talking about. Because sometimes if you are telling people these things, they may not really appreciate the seriousness of what you're talking about. It's like going to CAC's, Corporate Affairs Commission. Do you know how many applications CAC is processing every day? Or it's like going to a transcript office of a university in Nigeria. I remember when I was processing my transcript at the University of Ibadan. That place, if you do, at the time when I did some years ago, if you don't follow up your application, as soon as it's almost as if as soon as you are leaving, you put it down. They take another person's one, the person that has come to stay on their neck. As soon as that person leaves, they put it down. They take the next person that has come to stay on their neck. So these things are, so that's part of the things you're paying your lawyer for too. Like I said, so if your lawyer is, for instance, someone that has maybe their practice, in Nigeria, we mostly don't have specialized practice, but there are some lawyers that have it. So if, for instance, that's the lawyer's main practice, and maybe the lawyer will be there at the probate registry Monday to Friday, following up like 10 applications at the same time, you know that your work may come out faster than a lawyer that is in court for litigation today, that is in Abuja tomorrow for another litigation, that is in Spain tomorrow for arbitration, and then comes back next week to check the application he or she dropped last week. at the probate registry. So those are just some of the things that may affect the timing, but usually just budget 6 months to 2 years, for the final letter to come out. So once you pay, you supply those information in their form, they give you another date to come, and then when you come, they would have processed the information into a set of forms, statutory forms, about 5 or 6. They all have their names on it. I didn't hold a copy. I would have been reading out the names on those forms to you. So you have to take those forms back to your client. If you're a lawyer processing for a client, or if you're a client, you have to now supply some information in that form. And if part of what you're processing is monies in bank, you have to take one of those forms to the bank or all the banks where the deceased has monies, for them to endorse on that form the actual value in the account as at the date when you got there. So, for instance, if you are processing monies in a pension account that is paid monthly, maybe when the person died, they already had 1 million in their pension account. By the time you decide to process letters of administration and reach that stage, they might have 1.5 million. And by the time the final order is given, they may already have 2 million naira. But when you take it to the bank or to the authority, where the monies are being held, they will endorse the amount as at the date of endorsement, maybe 1.5 million naira as at today. And then the letter of administration will give you authority, lawful authority, to administer that 1.5 million naira and any other money that comes in after that. So you cannot go to the probate registry and say that, oh, this person has 1 million, because that's what you knew as at the time they died, possibly. So if you say that, you'll be shortchanging yourself. So you have to go and get the actual amount. I remember there was a letter of administration I processed, and I think maybe we had put our mind at some amount of money, very smaller amount of money. By the time we finished, when they took their letter to the bank to withdraw what was inside, they were so happy because the money was now much more than what we started with, because the pension kept flowing into that account monthly. So that also, you may not know the amount. That is why you need to take it to the bank, because if the person's phone is not with you, or the person is a secretive person and they didn't even tell you about some monies in some banks, which some people don't tell their family members, and those monies are sometimes gone forever, this process will help you to determine how much. Also, if I'm not accusing anybody of anything, but I'm just saying, if maybe there's internal knowledge in the bank that the person has died and they're trying to sit on some amounts of money. We've heard of bank frauds, of this nature. If you know the amount before the person died, or you have an estimate, by the time you take this form and they endorse what is inside for you, if the bankers are trying to be smart to reduce the amount or to swindle you, you'll be able to know. That is one other usefulness. That no, by my calculations, or by what this person told me, it should be 2 billion naira. What do you mean what you have is 1 billion and some millions? What do you mean by that? So these are some of the things that come up during the process. So when all the banks have endorsed the amount, then what you do next is that they will endorse it, put their, not just right though, the bank stamp has to be there, because there was a time I was processing and they are taking it to the bank and they had endorsed for them and they did not stamp it. So I had to take it myself back to, I don't want to mention the name of that bank because no free publicity, to that bank, as their lawyer with lawful authorities to process, and ask that the probate registry rejected it too. So they had to put their stamp and sign against it, the officer in the bank, that we are the one that endorsed this figure. This is the actual figure. So I think between the time that my client took that letter and brought it back, the amount had increased. So they put, if I'm remembering it correctly, they put the amount that was there on the date that I went and put their stamp on it and the signature, because there were several banks that endorsed on that form. So when you complete that process, you take it back to the probate registry for the next step, and then you go through what is called you swear affidavits. At some point, you swear affidavits where you depose to some certain facts, and then you would also there's a process called publication. It's for 21 days. Publication, that is when they will publish the fact that they are already processing letters of administration with respect to this person's estate. So if anyone has an objection, they should come up and flag it now. So that's what I said earlier, that if there's infighting in the family, and some people who believe they should be the lawful administrators find out that you have reached publication state without their knowledge, they can go and flag it, and then the probate registry will pause the process. And also, if a section or faction of kin starts the process and another section of faction wants to start the process, now it may be difficult. So if there are two processes, they may peg both, or they may peg both. Let me just put it like that. So it's important for a family to come with a united front. Also, nothing is lost, even if a section of the family that has no lawful right, gets the administration, the letter of administration, by hook or crook. If you believe that you are the rightful administrator, you can challenge it in court, because the letter is the authority of the court, the authority of the state to administer the estate. So you can challenge it at the state high court, proving that they are not the rightful persons and that they have perjured, because they would have sworn an affidavit in the process saying that they are the rightful administrators, they know of no impediment, they are this, they are that. So you can prove that they have perjured and that they are not the rightful administrators. So those I'm addressing many of the concerns that have come up. So I'm addressing questions. That people have asked me, that they raised over the years. So once you finish the publication, then and then you've done the affidavit, the publication, and everything, and then you wait for some time. If it may take a longer period if you're administering landed property too, very important, because then they would have to transfer the file to the section that does the landed property valuation, because they would have to visit the land physically. Probate registries know how they do these things. Let me not talk too much. So they visit the land, they value it. You have to provide them with information. You have to provide the title to the land, showing that the person is the rightful owner, and then you have to pay some monies for them to actually fill their car to go visit the land, and then to value it. Then you pay valuation fee. Yes, I think I skipped valuation fee. You're going to pay. They are going to value what you're administering, both the monies, the movables, immovable property, everything, and then you pay a certain percentage, depending on what is in the law, the estate administration law. You pay a certain percentage to the coffers of the government, and then you come back with receipt. In some states, like in Lagos, there's a specialized receipt you have to come back with. I know I had that issue when I did my first letter of administration. So you don't just go and pay. You have to pay into this particular bank, the bank branch. You have to pay into the bank branch, the specific bank branch that Lagos State was using at the time, and get a specialized certificate, a specialized receipt teller, not just the ordinary teller. So because I just ask clients, go and pay this. If it's to pay money, I don't undo it for you people. Just go and pay, so that you don't think lawyer is swindling us, lawyer is collecting money. No. If they ask you to pay this, I want you to go and pay, get the receipt yourself, see what you're paying for, and know that you're paying to the government directly. Then bring me the receipt, let me continue the process. So that also, you have to be mindful of that. And then at the end of the day, you're going to get the letter of administration. They will tell you, the registrar will tell you when to come back, and if there's any delay, they will explain to you once you keep following up. This is what is delaying. I know there was a period we were processing letters of administration, and they were like, oh, there's some internal change in government. The chief registrar or the probate registrar was promoted to so and so office, and so the person deputizing for him could not sign many of the, they did not have the lawful authority to sign some things, so we had to wait for them to process this and that, so, but eventually you will get your letter of administration. So now when you get it, what does it mean? It means that you can now present that at all the places where maybe you need to collect something that belongs to that deceased person, maybe at the bank, at their former place of employment, to the companies where they own shares to collect their dividends, or to buy and sell their shares. You can also attach it when you're disposing of their landed property to show that you are the rightful person, because now it means that you are the lawful person authorized to administer, to operate their estates, to buy, to sell, and to do whatsoever. So it's a position of trust anyways, because you'll be required to give an account to the state, periodically. And the state, and if you are mismanaging the estate, there's penalty for that. So it's not just a blank check, because most people just think, let us just get it and collect this person's money. So for instance, if it's an ongoing estate, like maybe a company or a business that is generating income that is going to continue to be in existence, you have to keep giving periodic reports of how it is doing, filing the appropriate returns, and keeping the books straight, So that is essentially what the letter of administration does, or what it allows you to do. Then, what if by the time you finish, there's a need for you to, maybe you skipped some properties or you did not know of them, now you want to add them? Very easy, very simple, because this is also something that you need to know. You can apply to the probate registrar to add those properties, those portions of the estate, to the estate. It's not that you are going to get another letter of administration. They will add it. So you apply to add those things. Also, like I mentioned, if you want to remove some things from the administration, from the estate administrator, maybe after you had started the process, you realize that something should not be part. Well, in my own case, for the client that had me remove, some things, I wouldn't know why they did that, but it was a family decision at the time. They said they wanted to remove those properties so to be administered. So all you need to do is write a separate application, asking for, I think, to pay a fee. And I just paid it out of my pocket. I remember that time I didn't even bother to ask them or anything. So you pay a certain amount of money, I think, if I'm remembering correctly, because that's the only time that I've had to remove from the estate that we started to process. So that's why I'm trying to remember. So you can apply to remove part of the estate before the process is completed. So that portion will be removed, and then you can continue processing the rest of the estate. So that is what letters of administration is all about. These are some of the important things that I thought to discuss on this channel. Essentially, you have to look at the law and see what the law says. There's a video we've done online of intestate succession. The right persons should apply for letters of administration. You have to bring proof of connection to the deceased. You pay some fees to the government. You pay valuation fees. No one is swindling you. You are using money to collect authority to collect money from the estate of your deceased loved one. And then you can always ask your questions at the probate registry. You should cooperate with your lawyer if you have retained the services of a lawyer. And the authority grants you ability to administer the estate and whatsoever comes into the estate after that in perpetuity. So you will see it in the letter of administration, where it's written that you can administer these things that have been stated, and then other things are coming to the estate as time goes on. And by law, you are expected to give account of the estate as an administrator. So it is not an opportunity for you to mismanage the estate. And so these are some considerations. If you have any other considerations or things you've not talked about, please leave the comments in the comment section. This is probably the third video we'll do, or maybe the fourth video we'll do on administration of intestate estates on this channel. Please watch all those videos. I'm sure that the information coheres and you'll be able to find whatever you're looking for. But if you need a personal explanation, maybe your own question or your challenge is personal to you, you can book a paid consultation using the link in the description box. That's what I want to talk to you about. Please like the video, share it, and don't forget to subscribe to Bar Talk with Ola. Toodles!